Hello, one and all. Welcome to the MOOCs program on Advanced Constitutional Law. This is Dr. Neelam, Assistant Professor, Punjab University Regional Centre, Ludhiana. Today, I'll be discussing the topic of Special Status, Jammu and Kashmir and Special Provisions. The learning objectives of this topic are to understand and analyze the scope of Part 21 of the Constitution, to understand the genesis of special status granted to the state of Jammu and Kashmir and special provisions made for the other states, to study and analyze the need and significance for making special provisions for different states. Part 21 of the Constitution of India, titled as Temporary, Transitional and Special Provisions, deals with different articles. That is Article 370, Article 371 and then Article 371A till 371J. Article 370 of the Constitution of India has granted special status to the state of Jammu and Kashmir, and rest of the articles have made special provisions for the other states such as Maharashtra, Gujarat, Nagaland, Mizoram, Sikkim, Goa, Karnataka, etc. First of all, I'll be discussing Article 370 of the Constitution of India. Article 370 of Constitution, it embodies the conceptual framework of relationship between the Union of India and state of Jammu and Kashmir. It lays down broad features as to the special status given to the Jammu and Kashmir. It is contained in Part 21 of the Constitution, which is titled as Temporary, Transitional and Special Provision. The temporary nature of this article arises merely because the power to govern the relationship between the state of Jammu and Kashmir and the Union of India is given to the Constituent Assembly. All the modifications or exceptions which are made in the Constitution of India are made with the concurrence of the state of Jammu and Kashmir. However, Article 370 cannot be abrogated or repealed. It was held in the case of Sampat Kumar versus State of Jammu and Kashmir that though the title of Part 21 of the Constitution of India contained temporary and transitional word, yet it is currently in usage, and unless the requirements of Clause 3 of Article 370 are fulfilled, it will remain in force. Clause 3 of Article 370 clearly lays down that the President may by notification declare that Article 370 shall cease to be operative or shall be operative with such modifications and exceptions as the President may by order specify. But this can be done only with the recommendation of the Constituent Assembly. Similar judgment was given in the case of State Bank of India versus Santosh Gupta. This judgment was given in the year 2017. It was also held in this case that state of Jammu and Kashmir has no vestige of sovereignty outside the Constitution of India. It is really improper to define the state of Jammu and Kashmir as sovereign, in the sense that the residents of Jammu and Kashmir constitutes a class in itself. The residents of this state, they are citizens of India. I would like to restate here that Section 3 of the Constitution of Jammu and Kashmir has clearly stated that the state of Jammu and Kashmir is and shall be a part of Union of India. Now, I would like to discuss different provisions which are contained in the Article 370. Article 370, Clause 1, Subclause A says that Article 238 of the Constitution of India shall not apply to the state of Jammu and Kashmir. However, this Article 238 has already been repealed. Article 370, Clause 1, Subclause B deals with the lawmaking power of the Parliament. The question is whether the Parliament can make laws for the state of Jammu and Kashmir or not. And this question is answered by Article 370, Clause 1 and Subclause B, which clearly says that Parliament can make laws on those matters which corresponds to the matters given in the instrument of accession and which are declared so by the President in consultation with the state government. Now, what are the subjects, or you can say the matters, which are given in the instrument of accession? Those subjects are defense, foreign affairs, and communications. On all these matters, Parliament can make laws, but with the consultation of state government. Now the question is whether the Parliament can make laws on other matters which are other than the matters there in the instrument of accession. Article 370, Clause 1, Subclause B says, yes, Parliament can make laws on those matters also which are other than the matters specified in instrument of accession, but with the concurrence of state government. Now there is a difference. If the law is made on the matters which correspond to the matters given in the instrument of accession, then only the consultation of state government is required. But in case of other matters which do not correspond with the instrument of accession, in that case, only consultation will not do. It can be made only with the concurrence of the state government. Now, next is the applicability of different provisions of the Constitution of India to the state of Jammu and Kashmir. Article 370, Clause 1, Subclause C clearly says that Article 1 of Constitution of India shall apply to the state of Jammu and Kashmir, and this article defines the territory of Union of India. Article 370, Clause 1, Subclause D talks about the applicability of other constitutional provisions to the state of Jammu and Kashmir. It clearly says that such other provisions of the Constitution of India can be made applicable to the state of Jammu and Kashmir subject to such modifications or exceptions as the President may by order specify. Now, what this term modify means? It was held in the case of Puranlal Lakhanpal versus the President of India that the word modification in Article 370 should be given the widest possible interpretation. This word modification also includes amendment. It cannot be limited only to those modifications which do not make any radical transformation. Now, in this subclause, that is subclause D of Article 370, Clause 1, there are two provisos which have been provided. Now, what are those two provisos? Now, the first proviso which is given, it provides that in case the constitutional provisions which are made applicable to the state of Jammu and Kashmir relates to those matters which are specified in the instrument of accession, then in that case, consultation of the state government is required. But in case of the other matters which are not specified in the instrument of accession, in that case, concurrence of the state government is required. Article 370 clause 2 further says that in case the concurrence of the state government is given before the Constituent Assembly has been convened, then in that case the matter shall be kept before the Assembly for the decision thereof. Now subclause 3 of Article 370. This subclause I have already discussed with you, which clearly says that the President may by notification declare that Article 370 shall cease to be in operation or shall be operative only subject to such modifications or exceptions as the President may by order specify. But this can only be done with the recommendation of the Constituent Assembly. This was all about the various provisions of Article 370 of Constitution of India. In the second video, I'll be discussing whether the amendment to the Constitution is applicable to the state of Jammu and Kashmir or not, and what is the extent of autonomy enjoyed by the state of Jammu and Kashmir.